Good morning. The judgment which I am going to share today most helpful for public prosecutors and particularly those who are conducting cases as a special prosecutors in some of the important murder cases. And this Armstrong murder case also, the judgment will help for prosecution. At the same time, defense lawyers must go through the judgment, because if the judgment is referred by the prosecution, you have to give answer, because this such a judgment wherein the Supreme Court given lot of ratio in favor of the prosecution and admonishing their lapses at the time of investigation. At the same time, the Supreme Court also held some ratios in favor of the accused to give benefit of doubt. Actually, one political murder at Bihar held by fire shots, and CBI prosecuted this case. And 9 accused were there. The trial court offences are 302, 307, and so many offences are there. Then Evidence Act 118 was also discussed. I will read a short form of 302, 307, 333, 355 and 379. 27 of Arms Act. This 333 was because one of the bodyguard was also, gunshot was there. So the trial court convicted all the 9 accused, and the High Court acquitted all of them, giving benefit of doubt. Supreme Court, after elaborate discussion of every piece of evidence, favorably considered certain lapses of the prosecution by ignoring them, convicted A4 and A8, and acquitted other accused, 7 accused, as per trial High Court judgment. So most important ratios are, just I will read. Testimony of informant averring presence of said witness was contrary to his further bayan. Therefore, testimony eyewitness rejected, contrary to it. Then testimony of witness could not be dismissed due to minor contradiction or non-compliance with hospital protocols. Then you see, even though the witness may be accused in some other murder case, that is may not be prevented the court to disbelieve it. Rejection of testimony merely on the grounds of criminal background was erroneous. That was there. Thereafter, testimony of hostile witness should not be entirely rejected. Credible portions of testimony of the witness could still be considered after careful scrutiny. Then you see, one witness for some portion of the evidence she was hearsay, for other portion of the evidence she was direct evidence. Therefore, rejecting the evidence of wife of the deceased, because political rivalries of High Court was set aside, not accepted. Then non-seizure of vehicles and offences also say that is not discredit testimony of eyewitnesses. They say forwarding FIR promptly serves as safeguard against manipulation. If the court finds the witness to be truthful and credible, lack of cogent explanation for the delay may not be regarded as detrimental. Minor discrepancy regarding time and place regarding statement of eyewitnesses under section 161 were superficial, because considering 4 and 6 years, that was accepted. They say the evidence of eyewitness, which was not available under 161's statement, may not be considered as a witness was doubtful because of long length of time. Then exit injury. Exit injury is if you suppose any person fired, if bullet entered into his body, it's incised protruding injury. If it is just touch the body, and that is called exit injury. So that was also discussed. They say some fact about not mentioning by the bodyguards may not be undermine the testimonies against the culpability of accused, they say. So thereafter they have convicted. All these things you go through the judgment. This judgment will definitely help in these organized murder cases like Armstrong murder case. I hope you understand. Go through the judgment. This is AR 2024 Supreme Court Ramadevi versus State of Bihar. AR 2024 Supreme Court 5148 Ramadevi versus State of Bihar. Best wishes.